All right, we've hit the witching hour. It's 1:30. Welcome, my fellow patriots. I'm Judge Michael Warren. I happen to have been named Judge of the Decade by the International Association of Top Business Professionals in 2019. I'm the co-creator of Patriot Week with my then 10-year-old daughter, Leah, and we are very excited to have you join us for our second annual and first virtual Patriot Academy for this second session of September 12th. Patriot Week renews America's spirit by deepening the appreciation of the first principles, founding fathers, and other patriots, vital documents and speeches, and flags that make America the greatest nation in world history. Many of our current holidays have become over-commercialized or have lost their deeper meaning. We need to reinvigorate our appreciation and understanding of America's spirit. Anchored by the key dates of September 11th, that's the anniversary of the terrorist attacks, and September 17th, Constitution Day, the anniversary of the signing of the Constitution by our founding fathers, the schedule for each day has a separate focus. Again, Patriot Week started in 2009 when my then 10-year-old daughter, Leah, pounded on the table and demanded a new celebration for America. Patriot Week has been recognized by the U.S. Senate in a unanimous resolution last year, and we're very hopeful that another one will be passed this year, as well as by over 15 states with official gubernatorial and legislative proclamations and resolutions. Scores of K through 12 schools, those being public, traditional schools, charter schools, private and home schools, universities, community colleges, law schools, student groups, community organizations, such as Rotaries and Kiwanis, senior centers, religious centers, and others, cities and counties and courts and law firms and businesses, senior living communities, libraries, hospitals, historical groups, private homes, public officials, and others have engaged in a wide range of grassroots activities over the years, including panel discussions, speakers, lesson plans, festivals, parades, picnics, paloozas, 9/11 commemorations. We've had essay contests, audio contests for students, all kinds of different activities. It's very grassroots, and we're really thrilled to have this Patriot Academy today as one of our activities. Today, we will be discussing the themes of September 12th, and on 9/12, we commemorate the critical first principle of the rule of law, the iconic United States Supreme Court Justice John Marshall, the groundbreaking United States Supreme Court case of Marbury versus Madison, and the Betsy Ross flag. Before we jump into this, I do want to mention one thing, which is that for those of you that are on Zoom, there's this, if you look at the bottom of your frame, you'll see that there's a chat function, and you're welcome to ask questions via the chat, and hopefully we'll have time to be able to answer. I've promised everybody we're just going to do this for an hour. Last night we ran right up to the hour, but I think we're going to have a little bit more time today. So if you have questions, feel free to submit them, and we'll try to get to them. Also, for those of you that are watching on Facebook Live and you have a question, you can certainly submit it there, and we'll try our best to juggle the questions. Well, we're going to begin discussing the first principle of the rule of law. And America was unique in the course of human history because when we declared independence, we did so in defense of certain founding beliefs, what we call the first principles. Now, James Madison, who we're going to learn about another day in our Patriot Academy, remarked about the importance of the American Revolution for the world. He stated, "Happily for America, happily we trust for the whole human race, the founding fathers pursued a new and more noble course. They accomplished a revolution which has no parallel in the annals of human society. They reared the fabrics of governments which have no model on the face of the globe." When our founders pursued this new and more noble course, they did so following what we term the first principles. And the core of those beliefs are laid out in the second paragraph of the Declaration of Independence, when it declares, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, and that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. That when any form of government becomes destructive to these ends, it is the right of the people to alter or abolish it and to institute new government, laying its foundation on such principles and organizing its power in such form as to them so seem most likely to affect their safety and happiness." From these eloquent sentences, we can identify 6 first principles: the rule of law, unalienable rights, the social compact, equality, limited government, and the right to alter or abolish an oppressive government, that is revolution. Yesterday we covered revolution. If you've missed yesterday's lesson, you can go to my Facebook page, and it was Facebook Live there. And we're also going to be uploading this onto our website, the whole series, so eventually you can review it. We will be addressing each principle throughout the week that we're doing these lessons. Today we are turning to the first principle, the rule of law. For most of, let me rephrase that. For most of human history, justifying the ruling government went no further than the point of a sword. As John Adams described, quote, in the earliest ages of the world, absolute monarchy seems to have been the universal form of government. Kings and a few of their great counselors and captains exercised a cruel tyranny over the people, unquote. Thomas Jefferson, writing to John Adams, and we're going to learn about those. We learned about John Adams yesterday. We're going to learn about Thomas Jefferson later. Added that with the possible exception of the Dutch, quote, either force or corruption has been the principle of every modern government, unquote. Rulers mostly governed through fear. There were no citizens, only subjects beholden to the ruler. When Louis XIV said, I am the state, he expressed the essence of the doctrine of unlimited power. And that's a quote from Daniel Webster, a great orator and politician. Quote, he continued, by the rules of that system, the people were disconnected from the state. They are its subjects. It is their lord. These ideas, founded in the love of power, were long supported by the excess and abuse of it, unquote. History really is replete with just hundreds and thousands of examples of ruler who completely ignored the law, if there even was a law, when it is inconvenient or a barrier to their personal predilections. Rulers often proffered some kind of justification for the rule because, they had to try to say why they should be in charge, such as divine right. But as a political and practical matter, pharaoh and king, czar and baron, daimyo and emperor ruled by force. And such governments still exist today. Burma, Vietnam, China, North Korea, Cuba are just a few examples where oppressive regimes continue to rule the people by the barrel of a gun. The founding fathers, however, believed that power is not justification, only explanation. Simply put, governments maintained by violence or the threat of violence are illegitimate and unjust. As Jefferson concisely observed, quote, force cannot give right, unquote. Even well-meaning rulers are likely to be corrupted when not required to obey the law. Good laws make a good prince, observed Thomas Gordon. Now, he was a leading English radical Whig, who was very influential in the colonies. And he continued, because even, quote, the best men grow mischievous when they are set above laws. There's something so wanton and monstrous in its lawless power, and there scarce ever was a human spirit that could bear it, unquote. The founders, therefore, understood as an eternal truth that the rule of law is a fundamental principle, quote, upon which every free, unquote, honest and legal government must stand. John Adams explained the founders' understanding when he wrote that good government and the very definition of a republic is, quote, an empire of laws, unquote. Adams' distant cousin, Samuel Adams, who we really know because of his beer brewing acumen, and I forgot to bring my Sam Adams beer bottle today, but you know what I'm talking about, noted that, quote, the first principles of natural law and justice, unquote, include the government, quote, has no right to absolute arbitrary power over the lives and fortunes of the people, but is bound to see that justice is dispensed and the rights of the subjects be decided by promulgated, known, standing laws, unquote. Setting aside the tyranny of the past, George Washington could accurately remark that the American system is purely a government of laws, made and executed by the fair substitutes of the people alone. In America, the government is to govern the citizenry according to the law, not by the whims or fancies of the men and women who happen to hold positions of power at any given moment. By requiring our political leaders to enact and publish the law, and to adhere to the same law that applies to each citizen, the rule of law acts as a strong barrier against tyrannical and arbitrary government. So just to flesh this out for a moment, we have a constitution. It's written. The written law, it's the supreme law of the land. And as a written document, the people in the government are supposed to follow it. And as a written document, the people are supposed to follow it. So you have this conjoined expectation that the people that are in the government and the people that are the citizens all have to follow the same law. So you have the janitor to the CEO, the prisoner to the judge, to the president. We're all bound by the same law. That's absolutely essential to this idea of the rule of law. And one example of this, a potent example of the nation's adherence to the rule of law, was when we had the unprecedented resignation of Richard Nixon as president in 1974. Proving that even the most powerful man in the world is not above the law, constitutional processes forced Nixon to resign when his re-election campaign's burglary of the Democratic National Committee's headquarters at Watergate and his attempts to cover up the crime were exposed. Vice President Gerald Ford was sworn in as president. Ford assured the country at a swearing-in ceremony that Nixon's resignation and his assumption of power was an affirmation of the rule of law. He stated, "My fellow Americans, our long national nightmare is over. Our Constitution works. A great republic is a government of laws and not of men." Nothing proved Ford's words more true than Nixon's resignation and Ford's seamless assumption of power. The rule of law, as I stated, also requires the same law govern all citizens. Samuel Adams observed that the rule of law means that there shall be one rule of justice for the rich and the poor, for the favored in the court and the countryman at the plow. And United States Supreme Court Justice John Marshall similarly reflected that in view of the Constitution, in the eye of the law, there is in this country no superior, dominant ruling class of citizens. There is no caste here. In respect of civil rights, all citizens are equal before the law. The humblest is the peer to the most powerful. That our citizens must abide by the law is essential to this idea of the rule of law. And in his farewell address in 1796, George Washington observed that the very idea of the power and right of the people to establish government presupposes the duty of every individual to obey the established government. All obstructions to the execution of the laws are destructive of this fundamental principle and a fatal tendency. Abraham Lincoln reaffirmed Washington's view by recognizing that the failure of our citizens to adhere to the law would lead to chaos and anarchy. In his famous speech before the Men Young's Lyceum of Springfield, Illinois in 1838, Lincoln pleaded, "Let every American, every lover of liberty, every well-wisher to his posterity, swear by the blood of the Revolution never to violate in the least particular the laws of the country, and never to tolerate their violation by others." He explained that adherence to the rule of law, even in the face of unpopular or unjust laws, was critical to preserving freedom and liberty. This is his quote: "As the Patriots of '76 did to support the Constitution and the laws, let every American pledge his life, his property, and his sacred honor. Let every man remember that to violate the law is to trample on the blood of his father and to tear down the charter of his own and his children's liberty. And in short, let it become the political religion of the nation, and let the old and the young, the rich and the poor, the grave and the gay of all sexes and tongues and colors and conditions sacrifice unceasingly upon his altars. When I so pressingly urge a strict observance of all the laws, let me not be understood as saying there are no bad laws, or that grievances may not arise for the redress of which no legal provisions have been made. I mean to say no such thing. But I do mean to say that although bad laws, if they exist, should be repealed as soon as possible, still, while they are in force, for the sake of example, they should be religiously observed." Echoing Lincoln's comments nearly 130 years later, President John F. Kennedy insightfully observed that our nation is founded on the principle that observance of the law is the eternal safeguard of liberty, and defiance of the law is the surest road to tyranny. By requiring our leaders and citizens to be governed by the same law, the rule of law is the foundation of our liberties. The Constitution and the law, after all, would be irrelevant if they did not authentically govern our political leadership and citizenry. As Dr. Joseph Warren, a leading colonial figure of the movement towards revolution and kind of an indirect descendant of mine, stated, if charters are not deemed sacred, how miserable, precarious is everything else founded on them. Nothing is more common in modern history than a government that crushed the freedom of its citizens despite a piece of paper labeled a constitution, purportedly prohibiting the government's oppressive actions. The entire American constitutional order is designed to secure our freedom and presupposes the rule of law. Washington explained again in his farewell address that respect for the Constitution's authority, compliance with its laws, acquiescence in its measures, are duties enjoined by the fundamental maxims of true liberty. Due process, freedom of speech, freedom of religion, freedom from arbitrary arrests and searches, the right to vote, and all other individual rights are animated by the rule of law and lifeless without it. Structural protections such as the separation of powers and checks and balances would be just vacuous parchment barriers without a vigorous dedication to their enforcement. Without an underlying commitment to the rule of law, courts do not dispense justice because their decisions are not based on the law, but on personal preferences. The legislature does not enact the will of the people, but its own whims, and the executive does not enforce the law, but its own desires. Accordingly, we shall have, quote, a government of laws and not men, unquote, is a bedrock of our first principles. With that, I'm now going to turn it over to Christina Billowis, who's going to introduce herself. She's going to address Chief Justice John Marshall and how important he is as one of the patriots that we celebrate during Patriot Week. And I will return at the conclusion after our other speakers have the opportunity to talk. Christina, the floor is yours.
Thank you so much, Judge. Pleasure being here. My name is Christina Billowis, and I am a family law practitioner with Kizia Law in Southfield, Michigan. And I have to say this discussion on the rule of law is quite fascinating and really dovetails nicely into discussion of the great patriot, John Marshall. Some fast facts concerning him. We know that he was Chief Justice of the United States, and he was the principal architect in consolidating and defining the powers of the Supreme Court. And essentially, he set the prevailing tone of American constitutional law. And so by way of brief background, John Marshall was the eldest of 15 children. He was born on September 24th, 1755, near Germantown, Virginia. And he was a man of humble origin, who through native ability and strength of character rose to relative prominence. He had sparse formal education, which consisted mainly of tutored lessons in the classics and Latin. And so moving forward with his life, we know that he was heavily involved in the American Revolution. He was a dedicated patriot from the outset, and he sought action with the Culpeper Minutemen in 1775. He was an officer of the Continental Line, and he took part in several major battles. And he also experienced firsthand the hardships of Valley Forge. His experiences, fortified by his association with George Washington and other nationalist leaders, left him with a passionate love of union and chronic distrust of state particularism, and later became one of the twin pillars of his constitutional law. He ultimately decided as his profession, the law itself. And during the summer of 1780, he was licensed to practice, and that August, he was admitted to the county bar. So segueing into his early political career, Marshall had a natural eloquence, he had a charismatic personality, and he had a rare gift for logical analysis. And those abilities overcame his deficiencies in his legal education. He rose quickly to be the head of the Richmond Bar, and he also distinguished himself with state politics. He sat in the House of Burgesses, where he consistently supported nationalist measures. He also served on the important committee on the Courts of Justice, and when he was only 27 years of age, was elected by the legislature to the Governor's Council of State. Ultimately, his legislative experience confirmed his belief that the Articles of Confederation needed to be strengthened against the irresponsible and selfish forces of state power. And as a delegate to Virginia for the Convention for the Ratification of the Federal Constitution, which was in 1788, he put his nationalist ideas to use. And though somewhat overshadowed by established statesmen, he spoke influentially for ratification. And on this hotly debated subject of the federal judiciary, he led the nationalist offensive. Now, looking forward in 1795, there was a crisis over the Jay Treaty, where party lines began to crystallize. Marshall supported Washington and Alexander Hamilton against the Jeffersonian Republicans. And as a lawyer in the Supreme Court case of Ware versus Hamilton in 1796, he adhered to Federalist principles by arguing the supremacy of national law. He turned down offers from President Washington to be Attorney General and Minister to France. And in 1797, he agreed to serve on the XYZ mission to France. And shortly after his return, President John Adams offered him an appointment to the Supreme Court, but at the time he declined. In 1798, John Marshall was elected to Congress, and he soon became a leader of the Federalists to the House. Declining to serve as Secretary of War, he accepted an appointment in 1800 as Secretary of State. 8 months later, Adams appointed him Chief Justice to the Supreme Court, hoping to hold back the forces of state rights democracy, which in the form of the Jeffersonian Republicans had gained control of the federal government. Moving forward to his career as Chief Justice, Marshall took his seat on the court on March 5, 1801, and from that time until his death was absorbed in judicial duties. He did find time, however, to write a 5-volume biography of George Washington and to serve in the Virginia Constitutional Convention. The pressing problem in 1801 was to unify and strengthen the court, and accordingly, he persuaded his colleagues to abandon the practice of delivering separate opinions and to permit him to write the opinion of the court, which he did in the great majority of cases from 1801 to 1811. In addition, Marshall gave the court a needed victory. And as I understand, which will be discussed later in the programming, his opinion in Marbury versus Madison is an influential and important case, which will be addressed in more detail later on in this program. Moving on to other cases, in United States versus Peters, which was in 1809, Marshall struck another blow for judicial power, and this time against the claims of a state, by establishing the court's right to be the first final interpreter of federal law. His opinion in Fletcher versus Peck held that the contract clause of the Constitution prevented state legislators from repealing grants of land to private interest groups. This was the first time in a series of contract decisions that encouraged the growth of corporate capitalism. Few of Marshall's opinions touched civil rights, but in the Ehrenberg treason case, he struck a powerful blow for political freedom by defining treason narrowly and required strict proof for conviction. Some of the president's sentencing cases we'll discuss is Mcclellan versus Maryland of 1819, where Marshall upheld the Congressional Act chartering the Second Bank of the United States, and thereby securing a national currency and credit structure for interstate capitalism. Also, by authorizing Congress to go beyond enumerated powers through a broad interpretation of the necessary and proper clause, he created a body of implied national powers. In 1824, the Gibbons versus Ogden case was decided, and Marshall's opinion gave Congress supreme and comprehensive authority within the enumerated powers of Article 1, Section 8 of the Constitution. The definition of commerce in the Gibbons case was sufficiently broad to bring the revolutionary developments in transportation and communication of the 20th century within the scope of congressional authority. And those two cases created a reservoir of national power and guaranteed a flexible constitution that could meet the nation's changing needs. That the court should be the final interpreter of the flexible constitution was the message of Marshall's compelling opinion in Cohen's v. Virginia of 1821. Marshall's own concept of the nation was thus: he did not intend to destroy the states or establish the nation as an end in itself. He envisioned the national good of the sum of the productive individuals who constituted it, each pursuing his own self-interest. And Marshall's opinions worked to release the creative energies of private enterprise and create a national arena for their operation. In Dartmouth College versus Woodward in 1819, Marshall ruled that a corporation charter was a contract within the meaning of the Constitution, which the states could not impair. As a result, private educational institutions, along with hundreds of business corporations chartered by the states, were secured against state interference. And the unleashed powers and forces of commerce, Marshall believed, would transcend selfish provincialism and create a powerful, self-sufficient nation. And around states' rights pressures, which rose in the 1820s, forced the Marshall Court to curtail its nationalism. In addition, new appointments to the court allowed division and dissent to burst into the open. The Chief Justice did not surrender national principles, evidence in cases such as Brown versus Maryland of 1827 and in 1832 in the case of Worcester versus Georgia, and he continued to lead the court, but the age of judicial creativity was temporarily over. With the election of President Andrew Jackson in 1828, Marshall became increasingly pessimistic. And meanwhile, his own personal life, he suffered the death of his wife, which left him disconsolate. After his own health began to fail, though he remained intellectually alert and continued performing his duties until his death on July 6, 1835. Marshall died believing that the Constitution and the Republic for which he had labored were gone, but history had proved him wrong. The nation continued along the course of nationalism and capitalism that had done so much to establish, and that the court and the law continued to follow the lines he projected. His reputation as the great Chief Justice seemed secure. I'll turn it back over to Judge Warren. Thank you.
Just give me 1 second. Sorry about this. Christina, that was fabulous. We really appreciate your fascinating review of a fascinating patriot. It is outstanding to be able to hear how a single person can make such a huge difference in the course of a country. And he certainly did that. And his legacy continues to abound as we move forward with our legacy. Our next speaker is Alex Ayar. I'm going to let him introduce himself as well, and he will be discussing the most important case of Marbury versus Madison. Alex, the floor is yours.
Hello, everyone. My name is Alex Ayar. I'm an attorney. I've been practicing law in Michigan for nearly 15 years, and today I'm going to discuss one of my favorite cases, Marbury versus Madison. I still remember vividly my constitutional professor discussing this case while in law school. So what's this case all about? All right, so Marbury versus Madison is a landmark United States Supreme Court case decided over 200 years ago in 1803. The opinion was written by Chief Justice John Marshall, who we just learned so much about. It is considered to be considered to be the foundation of U.S. constitutional laws because it establishes the doctrine of judicial review. So under the doctrine of judicial review, the actions of the executive and legislative branches of government are subject to review by the court to ensure that those branches abide by the Constitution. Essentially, it sets the court as a co-equal branch of government. So Marbury versus Madison has a rather politically charged background. So in the weeks before Thomas Jefferson's inauguration as president in 1801, 16 new judgeships were created through newly enacted laws, which then President John Adams proceeded to fill through the appointments. Sometimes these appointments are called the midnight appointments because they were made just a few days before President Adams' term ended. One of these judgeship appointments was William Marbury, who was actually one of the later judicial appointments. Although the US Senate quickly confirmed President Adams' appointments, not all the commissions were physically delivered in time. William Marbury was one of those who did not actually receive his commission before Thomas Jefferson became president. So Marbury's commission was like literally left on the desk and was not delivered. Once in office, Jefferson directed his Secretary of State, James Madison, not to deliver the commissions to those who were appointed by President Adams that were not already delivered, even though they were confirmed by the Senate. So Marbury went directly to the Supreme Court and petitioned the court to issue a writ of mandamus to compel Madison to deliver his commission. Marbury argued that signing and sealing the commission completed the transaction and that delivery, in any event, constituted a mere formality. The Supreme Court reduced the case to three key issues. One, did Marbury have the right to the commission? Two, if he did and his right had been violated, did the law provide him with a remedy? And three, and this is the critical one, if it did, would the proper remedy be a writ of mandamus from the Supreme Court? In its ruling, The Supreme Court held that the validity of a commission existed once a president signed it and transmitted it to the Secretary of State to affix the seal. Presidential discretion ended there, for the political decision had been made and the Secretary of State had only a ministerial task to perform, delivering the commission, and that the law bounded him, like anyone else, to obey. Having decided that Marbury had the right to the commission, the Supreme Court turned to the question of remedy, and once again found that in Marbury's favor, holding, and I quote, having his legal title to the office, Marbury has a consequent right to the commission, a refusal to deliver, which is in plain violation of that right, for which the laws of this country afforded him a remedy. Now the last issue. The court addressed the critical issue, should the court issue a writ of mandamus? There, the court held no. The court should not. The Supreme Court ruled that because the relevant provision of the laws upon which Marbury was appointed were unconstitutional and in violation of Article 3, Section 2 of the Constitution, the court struck down those sections of the law that violated the U.S. Constitution and found that the courts have the power to invalidate laws that violate the Constitution. And with that ruling, established the doctrine of judicial review. The principle fits well in our government's commitment of checks and balances. And near the end of the Marbury opinion, the court opined that a law repugnant to the Constitution is void, and that courts, as well as all other departments, are bound by that instrument, the Constitution. Thank you, everyone. I turn it back over to Judge Warren.
Alex, again, another fabulous presentation. We very much appreciate it. My fellow Patriots, our last presenter today is going to be John Wilson. John is a Patriot Week board member. I'm going to let him introduce himself and explain to you quite a bit about our flag for today, which is the Betsy Ross flag. It's not the flag behind me. You can see this is the Bennington flag. That's from last night's presentation. But John will be able to walk us through the mythical and quite inspiring Betsy Ross flag. John, the floor is yours.
Thank you very much, Judge. Can everybody hear me?
I can definitely hear you.
Okay, very good.
Yes.
Welcome, everybody. So one of the fun things so far, this is day 2 on the flags, that there's all sorts of legends surrounding these flags, and nobody really knows exactly what's accurate and what's not. But first, it's about the Betsy Ross flag. Who is Betsy Ross? Betsy Ross is kind of a famous person now in the Revolutionary era. She was a Quaker from Pennsylvania, ended up being shunned by her family and the Quakers because she had the audacity to marry an Episcopalian, and interdenominational marriage was not very well looked upon by the Quakers. Her first husband passed away within a year or two, a couple years of her marriage. And then she remarried and rejoined the Quakers, this time as a free Quaker, which meant that she was part of the Quakers that were not loyalists, but were supporting the Revolutionary War effort. A few other little fun facts behind some of the disputes was that Betsy Ross, it's deemed by historians, probably didn't design the flag. There's some suggestion that Francis Hopkinson perhaps designed the flag, but it's not really certain. One thing also that's very noted is last night when we were looking at the Bennington flag, it was a 6-starred. The stars had 6 points in the circle of the constellation in the canton. This was the first time that the stars took on the form of a 5-pointed star in the Betsy Ross flag, our first flag. And to this day, as we look at Old Glory, the stars have 5 points. The true design inspiration remains somewhat of a mystery, but certainly scholars and plenty of evidence comes to the point of describing the origins of the stars and the stripes. Starting with the stripes, During the Revolutionary War era and into the 19th century, the, quote, rebellious stripes, end quote, were considered as the most important element of United States flags and were almost always mentioned before the stars because of their importance. The usage of the stripes in the flag may be linked to two pre-existing flags, an 1765 Sons of Liberty flag in that era flew in Boston. It had 9 red and white stripes, and these rebellious stripes would influence later designs, leading all the way up to the American Revolution. A flag used by Captain Abram Marco's Philadelphia Light Horse Troop in 1775, excuse me, had 13 blue and silver stripes. One of or both of these flags likely influenced the design of that first American flag. On the stars, the canton featuring the stars may have gradually replaced the Grand Union flag as hope for reconciliation faded. Regimental flags featuring stars in the blue canton, such as the Bennington flag that we saw, may have predated the 1777 flag resolution, which I will reference here in just a moment. Although early American flags featured stars with various numbers of points, once again, the 5-pointed star is the defining feature of the Betsy Ross flag. And despite all the legendary disputes as to what it may have been the origins of the Betsy Ross flag, or who designed it, there is no doubt that on June 14th, 1777, which is now Flag Day, the Continental Congress adopted the national flag through the following resolution: resolved that the flag of the United States be 13 stripes, alternate red and white, that the Union be 13 stars, white in a blue field representing a new constellation. On the other hand, George Washington is reported to have said that we take the stars from heaven, the red from our mother country, separating it by white stripes, thus showing that we have separated from her, and the white stripes shall go down to posterity, representing liberty. He also said, let the 13 stars in a circle stand as a new constellation in the heavens. Again, this quotation, credited to George Washington, again puts a preeminence on the meaning of the stripes. It has also been said on the seal of our nation that the colors, the white signifies purity and innocence, the red hardiness and valor, and blue, the color of the chief, at the top signifies vigilance, perseverance, and justice. So our first flag, the Betsy Ross flag, which is really the basis of what we fly today as Old Glory, and remains a vibrant and most beloved symbol of America. Judge, I didn't know how to tie this into the rule of law, but I was trying to. The Bennington flag I could tie into Revolution, but this one I really could. I was trying to look for John Marshall in the flag. I was trying to look for Marbury and Madison. I just couldn't find it. So best I could do.
Well, that was an outstanding presentation. We really appreciate it, John. And I guess what I would say is when Leah and I were trying to figure out the schedule for Patriot Week and why the Betsy Ross flag would be appropriate, since it was the initial flag of the United States adopted by the Congress, which through a law that represented the union of the states through the law. That was what we came up with.
Oh.
Tomorrow we'll do the social compact with the current U.S. flag, and that of course represents the current social compact of the 50 states. But not the easiest. I totally understand it.
Yeah.
I wanted to highlight something in connection with the rule of law in Marbury versus Madison and the power of judicial review. As we have a little bit of time, we've got a question. I'm going to get to that in just a second. But I wanted to flesh out something with a more modern example. So we often hear about Supreme Court cases deciding the constitutionality of various acts and or executive actions that are taken. And I want to give one that has percolated throughout our culture for quite a while. it was a really hot button topic. It's kind of fallen off the radar in the last couple of years, but I think really exemplifies why the rule of law is so important, and in particular judicial review. So the Constitution, and we're going to talk about more of this in the Patriot Academy lessons as we move forward through the week, is specifically designed to give Congress what we call enumerated powers. Those are express powers that they're listed out, they're written out. This is what Congress can do. The design of the Constitution plus the 10th Amendment show that if the Congress doesn't have the authority specifically listed out, then it doesn't have the authority at all. It is not a power of, or it does not have general powers, what we call police powers. It has to be specifically enumerated. Any other powers that might have been given to the federal government and weren't reside with the states, are reserved with the states. And the states do have what we call general police power. So that's very unique in the course of human history. And Article 1, Section 8 of the Constitution lists a series of different authorities that are given to the federal government. I won't go through the list, but it's actually relatively short. And the key one I'm going to focus on is the power to regulate commerce among the several states. That's called the commerce power. And the example I want to use is the Affordable Care Act, otherwise known as Obamacare. And you might remember there was a huge debate about whether or not Congress could force people to buy health insurance. And when it went to the Supreme Court, those that were defending the healthcare law said that Congress had that power because of their ability to regulate interstate commerce. What I just said, they said healthcare affects, it's a big part of the economy. There's a lot of effects across the economy because of healthcare. We're going to mandate that somebody engage in commerce by buying the healthcare. It affects the market, and we need to do that for a variety of reasons. And the people that opposed it said, no, the power to regulate is not the power to force someone to do something. So that came up to the Supreme Court. And the Supreme Court, in a very slim 5-4 to majority, blanched and struck down the provision of the Obamacare Act, which, or at least the argument behind the Obamacare Act that the federal government had the authority to force people to engage in commerce. And Chief Justice Roberts wrote that the individual mandate does not regulate existing commercial activity. It instead compels individuals to become active in commerce by purchasing a product on the ground that their failure to do so affects interstate commerce. Construing the Commerce Clause to permit Congress to regulate individuals precisely because they do nothing would open a new and potentially vast domain to congressional authority. Everyday individuals do not do an infinite number of things. In some cases, they decide not to do something at all. In other cases, they simply fail to do it. Allowing Congress to justify federal regulation by pointing to the effect of inaction on commerce would bring countless decisions an individual could potentially make within the scope of federal regulation, and under the government's theory, empower Congress to make those decisions for him. The government's theory here would effectively establish that individuals would be regulated under the Commerce Clause whenever enough of them are doing something the government would have them do. Indeed, the government's logic would justify a mandatory purchase to solve any problem. Now, the Supreme Court eventually affirmed the individual mandate as a tax penalty, but it specifically said that the federal government doesn't have the authority to force people to engage in commerce. And so it rejected the idea that the government was unlimited. And by doing so, it preserved the rule of law because it followed the text and the historical understanding of the Commerce Clause. And by doing that, it preserved the integrity of the Constitution and preserved individual liberty. So that's just one example. We could go through many, many different examples where the Supreme Court has struck down either executive actions or laws, and thereby preserving the integrity of the Constitution and the rule of law. So the question that we have is, if judicial review was such an important concept, why didn't the Constitution include that concept as part of the checks and balances? That's a great question. And at the beginning, when John Marshall rendered Marbury versus Madison, I should say the entire Supreme Court did, there was some controversy because the question is right. There wasn't a very specific statement about judicial review, but I will note that when you have a written constitution, that it doesn't mean anything if somebody can't ultimately enforce it. And what, if you read James Madison and Alexander Hamilton in the Federalist Papers, and they're discussing the judicial power, they made very clear that inherent in the judicial power is the requirement that that they be guardians of the Constitution, and that when other branches of government go beyond their scope, that it's the role and really the duty of the Supreme Court to strike down such unconstitutional actions. They're also very clear that they believe that that should be exercised cautiously. They don't expect it to happen very often, and that it should not be an excuse for judges to go off the rails and impose what they think the Constitution should say, but they have to adhere to what the Constitution really means. And so they say if they impose a constitutional decision on the country that's ungrounded in our history and the original meaning and the understanding and structure of the Constitution, they're just kind of making things up, and they become unmoored from what the law really is and the Constitution really is, then they are usurping the Congress's authority by creating law. And for example, I took an oath of office when I became a circuit court judge, and that oath of office is to, in part, to defend the Constitution of the United States and the state of Michigan, and therefore I'm not under that system. I don't write laws. I'm not a policymaker. That's for the Congress and the state legislature, and in some circumstances the president and the governor. It's not for me. And if I were to impose my own personal views, I would be violating my oath of office and would be usurping the authority of the people, because the whole point is that the people are the final source of authority, and it's the people that ratified the Constitution. And so when the Supreme Court enforces the Constitution against a legislative action or an executive action, it's enforcing the will of the people. And I'll give kind of an absurd example, but maybe there's no such thing anymore. But I use this in the Rule of Law forum that we had earlier today. So if you heard this, I apologize. But the Constitution says for someone to be a member of Congress in the House of Representatives, they have to be at least 25. They have to be a resident of the state that they live in. And they have to have lived in the state for a certain period of time. So let's say California, there's an election in California, and they elect someone to the House of Representatives who is 21, a Canadian, and doesn't live in California. They live in Michigan. Okay, so there's 3 reasons why that person shouldn't be qualified to serve as a congressperson. You say, well, how could that happen? Well, let's say they're a pop star. They've got a lot of money. They're notorious. Millions of people know who they are. And they give a lot of money to the majority party in Congress. So Congress, at least the majority, really wants them to be in there. To seat that person, even if they win an election, would obviously violate the Constitution. And the House of Representatives would be violating the rule of law if they seated that person. And likewise, if there's other obvious blatant violations of the law, like somebody runs for president, you have to be a natural born citizen, you have to be 35 years old, there's a residency requirement, and somebody runs and they wins, and they're 25, and they're not a resident of the United States, and they're not a citizen, they should not be seated as president. And it would be up to the Supreme Court to, in the end, if there was a lawsuit, because they can't just jump in. They have to make a decision in a lawsuit that's brought to them. But they could definitely say this person is not qualified. So you see an extreme example like that, and you go, okay, there needs to be someone that's the guardian of the supreme law of the land, and that is part and inherent in the judicial power. I don't know if Alex or Christina or John wanted to comment on that question or anything else I had to say.
No, Judge, I thought that was a wonderful dialogue and description enumerating that.
Yeah, I would agree. It was a great question, and Judge, you answered it really well. Thank you for doing that.
You're welcome. We have the chat room open if anybody else wants to send in a note. We're close to the end, but we'll give you a minute or two if anybody else wants to send in a question via the chat function at the bottom of your bar. Okay, it looks like we have satisfied everyone. I just want to wrap up. I want to again thank our presenters, John Wilson and Christina Billowis and Alex Ayar did a fabulous job, and they will be returning in one fashion or another in different lessons. So you've seen a great group of people. Hopefully you will come back and return. And I just wanted to give some closing comments in connection with Patriot Week in general. Fellow Patriots, I hope you enjoyed and learned something in the September 12th session of our Patriot Academy. And please return for future sessions. And don't forget to check out Patriot Lessons, American History and Civics podcast, our Patriot Lessons TV show.
Let me see the other pillow.
Somebody's got their, somebody's unmuted. So, all right. Our Patriot Lessons TV show, our lesson plans, daily celebrations, and so much more on patriotweek.org. You can follow us on Twitter, Facebook, Instagram, and LinkedIn. Also, you heard the reference to my book, America's Survival Guide. You can check that out on Amazon or other online retailers, or at americasurvivalguide.com. And please join us for the remaining of our sessions, including tomorrow. We will address the first principle of the social compact, George Washington, the congressional resolution forwarding the draft of the Constitution to the states for the ratification, and the current U.S. flag. Until next time, God bless you and God bless America. Everybody have a great day and stay safe.
Thanks a lot.
Thank you,
We
Judge.
enjoyed it.
Great.